Today, we are talking about the Alex Murdaugh of it all. But we're not talking about the Murdaugh murder of it all. We are talking about Murdaugh versus Courthouse Becky. And what is fascinating to me about this case is that it's going to be real interesting to see how this plays out when just everybody's wrong. I have no love lost for either of the parties in this lawsuit, but I still want to see how it plays out. And also, I think it's a really good exercise in Murdaugh can be wrong, but he can be right in this instance. Like what Courthouse Becky did is not correct, but it's really interesting to look at a case where you're looking at everybody going, great, good for you. But I'm real interested because today we're looking at Courthouse Becky's audacity in her motion to dismiss. And then we're looking at Murdaugh's clapback, which is a clapback, and all of the lawyer sass. But Courthouse Becky is claiming immunity. And it's not even like TikTok immunity. She's claiming like actual immunity from her fuckery. We're going to look at Courthouse Becky's motion to dismiss first, and we are going to go, sure, Jan. You will please take notice. God, South Carolina has some legal quirks that I just really enjoy. The defendant, by and through the undersigned counsel, respectfully moves this court to dismiss plaintiff's complaint for failure to state a claim upon which relief can be granted, or for this court's lack of subject matter jurisdiction pursuant to Rules 12b-6 and or Rules 12b-1. Y'all have been around long enough to know that your 12b-6 motion to dismiss for failure to state a claim generally doesn't get granted. And if they do, I have rarely seen them granted without leave to amend. There are very narrow circumstances where the court will say, I am granting the motion to dismiss with prejudice. You do not have leave to amend. A 12b-6 failure to state a claim is just on the four corners of the document. Does this document, as pled, not say a thing that is a cause of action? It is a pretty easy hurdle to overcome for defendants. And then lack of subject matter jurisdiction under 12b-1. I'm interested to see what her arguments are there. Defendant moves pursuant to Rule 12b-6 of the Federal Rules of Civil Procedure for dismissal of plaintiff's suit based upon plaintiff's failure to state a claim for relief. I think it's an interesting argument as we get there. I'm curious to see what the court does because I do think it's an interesting argument because they've nuanced it a little bit more than just nothing is wrong here. Plaintiff alleges, in short, that defendant's actions deprived him of an impartial jury and that he is, therefore, entitled to recover the full sum of money thus spent on his criminal defense. They mean he. We have pronoun problems again so early in this motion. Entitled to recover the full sum of money thus spent on his criminal defense trial. Such damages, they say, fall outside the scope of 42 U.S.C. 1983 and 1988. Those are the code sections here. So, can the relief that he is requesting, recouping the cost for the criminal trial, can that relief be granted? And I do think that that's an interesting question. Do you get back the cost? They say that the Fourth Circuit has never established that damages stemming from the legal costs associated with defending an underlying criminal case are redressable under the statute. I think the taxpayers of South Carolina should be able to sue Courthouse Becky for the millions they invariably spent the first trial and now are going to have to spend again. They go on to say, to the extent that other circuits have considered the question, they, along with the Fourth Circuit, have been clear that in the event such damages are recoverable, a plaintiff must show that his damages were caused by the defendant's actions. Such cannot be the case here, where the entirety of the economic damages claimed by the plaintiff would have been spent on his criminal defense regardless of any actions taken by this defendant. Again, I think this is a really interesting question because what Courthouse Becky is arguing is that you had to defend trial number 1 no matter what. And it's premature to ask for damages for trial number 2 because it hasn't happened yet. They go on to say that for much the same reasons, defendant, Courthouse Becky, is entitled to dismissal of plaintiff's claims pursuant to Rule 12b1 of the Federal Rules of Criminal Procedure, where the compensatory damages sought by the plaintiff are not traceable to defendant's actions. Finally, to the extent, if any, we've sidestepped the what if any, to the extent, if any, that plaintiff argues otherwise that inconsistent with his complaint, he seeks damages related to the second future trial, defendant likewise moves to dismiss plaintiff's complaint under Rule 12b1 of the FRCP under such theory. Plaintiff's damages have not and indeed might not ever accrue, and plaintiff's suit would therefore not be ripe for adjudication, divesting this court of jurisdiction to entertain the same. I'm not mad at the writing, and I think that's an eloquent way of saying it would be premature. It would not be ripe at this time because the damages haven't occurred yet. Finally, and most critically, even if plaintiff states a compensable claim, a tort of some type, defendant is nonetheless entitled to 11th Amendment immunity, quasi-judicial immunity, and qualified immunity, all of which bars plaintiff's suit. So no damages, throw the case out. Then we get to immunity. So now that we've gone through the notice, let's get into the memorandum of law in support of the motion to dismiss. Plaintiff brings the instant civil matter under 1983, seeking to recover compensatory damages, so compensation, compensatory damages for defendants' alleged constitutional violations of Murdaugh's Sixth Amendment right to a fair trial by an impartial jury secured by the 14th Amendment. Plaintiff seeks compensatory damages in the amount of $600,000, which represents the flat fee paid to plaintiff's legal defense team, a combination of attorneys from Griffin Humphreys and Richard A. Harpootlian, PA, for their work in his underlying state criminal trial. Plaintiff does not contend defendant's alleged constitutional violation of Murdaugh's Sixth Amendment right to a fair trial by an impartial jury secured against the states by the 14th Amendment caused plaintiff to incur the additional legal cost of defending any post-trial and appellate litigation or future retrial. And here's the thing. In a murder case, if there's a conviction, there is going to necessarily be appellate work no matter what. So the fight is, were any of these costs caused by and related to Courthouse Becky's behavior? And I do think that that's a really interesting question because he chose to have private representation. And I imagine that Alex Murdaugh paid this amount well before a jury was ever selected. They go on in header 1 saying the foundational principles, 1983's remedial provision, bar plaintiff's recovery of legal defense fees incurred in connection with his underlying state criminal trial. Plaintiff's suit is based upon a novel theory of liability and recovery. They say, to the undersigned counsel's knowledge, this is a case of first impression, meaning this has never happened before. No federal circuit or district court has addressed the question of whether a criminal defendant who alleges their Sixth Amendment right to an impartial jury has been violated can recover damages for the legal defense fees incurred in connection with the underlying state criminal proceeding in a subsequent civil suit brought pursuant to 1983. So interesting. Even expanding this inquiry beyond, they say, the narrow scope of the Sixth Amendment, the Fourth Circuit has never directly addressed whether a 1983 plaintiff, quote, can recover attorney's fees incurred in connection with an underlying state criminal proceeding. And that is a 2015 case that they're citing and a 2022 case that they're citing. They go on to say, absent such guiding law, remember, law always looks at what other judges have done. Among the age-old principle of judges, don't be weird. Don't do anything weird. What did the judges before us say? Great. I agree with them. Do that. Law is not about reinventing the wheel. It's about saying what happened before, how does that apply here? Absent such guiding law, defendant turns to general principles upon which 1983 remedies are based and to other circuits' treatment of plaintiff's theory of liability. This is actually an appropriate instance to take a look at what other circuits have done because there is no law within the Fourth Circuit. So then you look outside the circuit. What have other courts done elsewhere? The general purpose of damages under 1983 is to, quote, with, and they've bolded it, emphasis added, compensate persons for injuries that are caused by the deprivation of constitutional rights. They say that deterrence is also an important purpose of this system, but it operates through the mechanism of damages that are compensatory, damages grounded in determinations of plaintiff's actual losses. That doesn't say attorney's fees. This law is not written to put money into the attorney's pockets. They go on to say, like the common law tort claims upon which this code of the U.S. law are modeled, claims brought pursuant to 1983 require, quote, but for and proximate cause analysis. But for analysis is literally that. This, but for that. It's real easy in like a car accident example, because if your car is working perfectly fine and then somebody runs into it, your car was perfectly fine, but for someone running into it. And so it's pretty easy to say, well, it was perfectly fine before, and then you hit it, and now this is the damages. It's real easy to look at through that lens. But the but-for analysis is, this happened, and now I have to pay this money. I am damaged in this way because of the thing that you did. And I would have been fine, but for what you did. And so Courthouse Becky is saying, there's no but for here. The Fourth Circuit has never recognized 1983 as countenancing such a broad grant of damages, and those circuits that have addressed the issue have predominantly rejected such an approach. So this circuit's never addressed it. Circuits that have addressed it have said, you don't go here. Federal circuits are split as to whether 1983 permits recovery of legal fees incurred during an underlying state criminal proceeding. There is a split of authorities, which is also interesting. There is a split of authorities on the issue of whether a criminal defendant whose constitutional rights have been violated in an underlying state criminal proceeding can recover damages for incarceration, legal costs, fees, or emotional damage. They say emotional distress, but emotional damages. They go on to cite a New York case from 1999 that found that they were going to bar the recovery of attorney's fees and costs incurred in an underlying criminal proceeding where evidence for gun possession charges arose from a violation of the Fourth Amendment, which was probably like an illegal search. There's another 1988 case that they are saying the Ninth Circuit recognized recovery of money spent on legal representations defense of underlying acquitted criminal charges as compensatory damages for economic harm. So the Ninth Circuit has said yes. It seems that other circuits have said no. Emily, what do you do with a circuit split? Well, this circuit's going to have a really interesting time trying to decide what happens. And then no matter what the judge does here, it sounds like it's kind of ripe for appeal then. And maybe ultimately for Supreme Court review. They say that the court should adopt the Second Circuit's rationale barring recovery of legal fees incurred during an underlying state criminal proceeding in a subsequent 1983 action. So they're asking the court to adopt the methodology of analysis that is most friendly to them. Of course they are. Their next point is that there's no causal connection between defendant's alleged constitutional violation, Becky's, and the attorney's fees incurred by plaintiff in his underlying criminal trial. So the first thing was, hey, does the law allow for this kind of damage? The next question is, hey, is she the cause? So this is that proximate cause analysis. Her argument is that plaintiff is not entitled to recovery of his expenditures for legal representation in his underlying criminal proceeding. Plaintiff asserts that he, quote, funded his murder trial defense with a $600,000 withdrawal from his 401k retirement funds. I would like to point out that the only reason that Alex Murdaugh was able to put $600,000 into his 401k retirement fund is because he was stealing money everywhere fucking else. They say that initially the, quote, loss of such attorney's fees may constitute monetary harm potentially compensable under 1983. And then they're citing a case law that says compensatory damages may encompass, quote, out-of-pocket loss and other monetary harms. Plaintiff, however, has failed to feasibly allege that defendant's action caused the funds to be lost. I can understand this argument. Irrefutably, whether defendant acted improperly or tampered with the jury or not, the plaintiff was in either event going to face a verdict of guilty or not guilty from the jury. Accordingly, whether guilty or not, the plaintiff would have most certainly incurred the exact same amount of attorney's fees he now seeks to recover from the defendant as damages. I don't disagree. Honestly, I think if this gets to discovery, it will bear out that Murdaugh paid them $600,000 well in advance of this case ever picking a jury. They go on to say that plaintiff's claims for compensation damages must be dismissed for lack of subject matter jurisdiction because he lacks Article 3 standing. Article 3 of the United States Constitution grants this court the judicial power to resolve cases and controversies. Federal courts have the constitutional authority to decide and pronounce a judgment and carry it into effect between persons and parties who bring a case before it for decision. They go on to say that the doctrine of standing honors the limitations inherent in the assignment by ensuring judges attend to actual harms rather than abstract grievances. This is not like, hey man, can you settle an argument for us? This is, you have been harmed, we can rectify the harm. And in civil, that's with money. They're arguing here that because there's no way to compensate for the damage, there is no case in controversy, therefore there's no standing. If they get dismissed here, there is a possibility if the court finds no standing, that it could get dismissed with prejudice because the court could find there is no way on these facts at this time that Murdaugh could ever recover, no matter how he pleads this case, could ever recover that $600,000. So when you are throwing a case out for lack of standing, there is a possibility that the court can say, it doesn't matter what you say. You cannot, as a matter of law, recover for those $600,000. Dismissing this case with prejudice, I don't think would preclude Murdaugh from suing after the second trial. But then he would have to pay for the second trial, wouldn't he? And that doesn't seem to be happening. And then they get to the ripeness doctrine. Hey, if Murdaugh argues that he's entitled to the cost for the second trial, it's not ripe yet. It's not a controversy yet. It hasn't happened yet. It hasn't been paid yet. Court deals with things that have passed, not things that may happen in the future. Defendant Courthouse Becky argues at the very end, do you see the ordering of the arguments? Things that the court is going to take more notice of, and then to the end. The end is like, oh, by the way, if none of that works, immunity. This is the oh, by the way argument. Defendant is entitled to immunity under the 11th Amendment and under the doctrine of judicial immunity and qualified immunity. They say that if this court finds that plaintiff's complaint is not subject to dismissal based on the above arguments, then what? Then they say Courthouse Becky is entitled to immunity. Plaintiff alleges defendant is a constitutional officer of the state of South Carolina, elected as the clerk of court by the citizens of Colleton County, and that the actions taken by defendant were taken within her official role. Similarly, defendant is entitled to quasi-judicial immunity, where the actions complained of by the plaintiff were judicial in nature and related directly to the defendant's judicial responsibilities. I've not seen this extend beyond judges. I'm curious to see if Murdaugh will spend more of his motion attacking this than the other arguments. They say defendant is entitled to qualified immunity where it was not clearly established at the time of the alleged constitutional violations that defendant's actions violated plaintiff's right under the Sixth Amendment. As plaintiff alleges in his complaint, former Chief Justice Jean Toll denied plaintiff's motion for a new trial, finding the defendant's conduct amounted to harmless error. The South Carolina Supreme Court reversed the decision, acknowledging throughout its opinion the difficulty, the complexity, and the conflicting jurisprudence in the Sixth Amendment inquiry. The violative nature of defendant's conduct then, or violative, was neither readily apparent nor obvious to the former Chief Justice Toll nor the South Carolina Supreme Court. It could but have been wholly lost on defendant or any other reasonable clerk of court. Defendant is entitled to immunity under the 11th Amendment. The 11th Amendment of the Constitution of the United States establishes that judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state. Okay. But the Supreme Court has consistently held, they say, that an unconsenting state is immune from suits brought in federal courts by her own citizens as well as by citizens of another state. I do not think that this extends to her. They say that 11th Amendment immunity extends to arms of the state, including state agencies, state officers acting in their official capacity. I think there's a strong argument she was not here acting in her official capacity. They say, as plaintiff notes in his complaint, defendant was at all relevant times acting as the clerk of court for the Circuit Court of Colton County, South Carolina, a position which she was elected. The Colton County Clerk of Court's office is funded by the state of South Carolina. Unquestionably, defendant then is being sued as an arm of the state. She has neither waived the protections of the 11th Amendment nor consented to suit in federal court. Accordingly, she is entitled to 11th Amendment immunity. Defendant is entitled to quasi-judicial immunity. Defendant is likewise, they say, entitled to quasi-judicial immunity. They're going through all of the various immunities. Again, these are the oh by the ways. They say that because she was acting in her role, that, quote, the absolute immunity from suit for alleged deprivation of rights enjoyed by judges is matchless in its protection of judicial power. It shields judges even against allegations of malice or corruption. Judges. Quasi-judicial officials whose duties are comparable to those of judges or prosecutors are likewise, they say, entitled to absolute immunity. And such immunity extends to the judge's subordinates for functions that are more administrative in character that have been undertaken pursuant to a judge's explicit direction. That doesn't apply here either. They go on to say, accordingly, clerks of court are generally afforded quasi-judicial immunity from suit or claims involving, quote, tasks so integral or intertwined with the judicial process that these persons are considered an arm of the judicial officer who is immune. So it's kind of tacked on to the judicial immunity. I could see this coming up in a circumstance where a clerk like misentered a birth date and somebody with the same name got arrested because a misentered birth date created a warrant for the wrong person with the same name. And then they're suing because they wrongly got arrested because of somebody's typo. However, this isn't that. This isn't that. They also go on to say that she's entitled to qualified immunity, that even could plaintiff show that he suffered some constitutional deprivation, defendant is nonetheless entitled to qualified immunity. The Supreme Court held that government officials are shielded from liability in civil actions if their conduct does not violate clearly established statutory rights. Like jury tampering? And so then they are arguing that that would apply to Courthouse Becky's actions in this case. They say to determine whether a defendant is entitled to qualified immunity in this case, the court must make three determinations. So these are the questions you need to ask yourself. First, the court must identify the specific right allegedly violated by the defendant. Second, the court must determine whether at the time of the alleged violation, these rights were clearly established. Finally, the court must determine whether a reasonable person in the defendant's position would have known that their actions were in violation of another person's right. Ding, ding, ding. Would a reasonable person in Becky's shoes know that her actions were a violation of someone's rights? Here's their conclusion. The South Carolina Appellate Court found that those comments in other cases had no effect on the verdict of any juror, while the South Carolina Supreme Court held these statements were more than innocuous interventions. Upon presentation of these facts, astute analysis, and diligent research, the former Chief Justice of the Supreme Court of South Carolina found defendants' actions did not rise to the level of constitutional violations. They're talking about Justice Toll. This is to say that in light of pre-existing law, the unlawfulness was not apparent. It's a nuanced argument. What they are trying to say is that the wrongness of Becky's actions have to be apparent to Becky, and even Chief Justice Toll could not find that her actions were a constitutional violation, which is why Chief Justice Toll, under the law of the land at the time in South Carolina, denied the motion for new trial. So if the astute, learned, wise Chief Justice Toll could not find that this was a violation of law, how's Becky to know? That's the heart of this argument. But as we get to the end of this motion to dismiss, where are we? The heart of Courthouse Becky's attorney's arguments are sound. The argument in its simplest form, and I don't want to do an injustice. There's plenty of injustice that's been done in this case. I don't want to do an injustice to the good legal work that has been done in this filing. But the heart of the argument is similar to what we see in food court, where we see the judges saying that the party doesn't have standing because there's no actual harm. Like, were you harmed because you had to let your microwave mac and cheese cool before you ate it, so it was therefore not ready in 3 minutes? This is analogous to the arguments being made here that Courthouse Becky's violation, if there is one, of Alex Murdaugh's rights is not what cost him attorney's fees. So the heart of that argument is that Murdaugh cannot recover for the attorney's fees for trial number 1 because the attorney's fees were not incurred because of Becky's wrongdoing. And then the follow-up to that argument is, if Murdaugh tries to argue that he's entitled to attorney's fees for trial number 2, that hasn't happened yet. That money hasn't been spent. And that question is not ripe for judicial consideration. It's too early. And I think that they have a very interesting argument that may carry the day on this motion to dismiss. Here's the pickle. Alex Murdaugh's lawyers in interviews have said, well, the job's not done. So we're still doing this trial based on the monies Murdaugh has paid us in the past. And if Murdaugh can't pay them for the next trial, does he have standing to sue Courthouse Becky for deprivation of his rights, not his lawyer's rights, his rights, if they are doing trial number 2 based on the funds paid in trial number 1? If he's not paying them anymore, then there's nothing to recover. There's no damages. And if there's no damages, then there's no case in controversy, because under 12b-6, the motion to dismiss is failure to state a claim for which relief can be granted. Is there any relief in Murdaugh's case that can be granted? And that's the question that the court's going to grapple with. And it's a nuanced question, but it's not as far of a long shot as we've seen in some motions to dismiss. This was a very thorough, thoughtful, and I think artfully lawyered 40-page motion to dismiss. And I find myself real interested in what the court's going to do and if the court's going to bring this motion to dismiss for oral argument, because I think this is the type of motion that we might see the court want to have oral argument on and question the lawyers a little more fulsomely. Let's take a look at what Murdaugh has to say, because that damages question, man, so it's a real good legal question. Filed July 2nd, 2026, response to defendant's motion to dismiss. Plaintiff Richard Alexander Murdaugh, through his undersigned attorneys, submits this memorandum in response to the 44-page motion to dismiss. Excuse me, Your Honor, it's too many pages. In response to the 44-page motion to dismiss of defendant Rebecca Hill, Ms. Hill's motion to dismiss does not and cannot deny what the Supreme Court of South Carolina has held unanimously. They're not attacking the case, they're attacking the person. Ms. Hill's motion to dismiss does not and cannot deny what the South Carolina Supreme Court has held unanimously. That Ms. Hill, then the elected clerk of court, sworn to protect the jury, instead secretly tampered with it and thereby stole from Mr. Murdaugh his constitutional right to a fair and impartial jury. Having, quote, placed her fingers on the scales of justice for personal profit, Ms. Hill now asks this court to hold that she may do so without consequence. She cannot. They say Ms. Hill's motion is a make-weight damages motion masquerading as a motion to dismiss. Pound the table. We've gone directly to pound the table. It barely engages the elements of Murdaugh's 1983 claim. Oh no, it only attacks the one it needs to attack. If no damages, then no lawsuit. No, it doesn't attack the other claims. It narrows in with a laser-like focus on the one that's most likely to get this yeeted. Damages. And they argue damages like 3 different ways, including standing, which other federal courts in other cases have found persuasive. No damages, no standing, no lawsuit. Bye-bye. So they go on to highlight that the heart of Murdaugh's claim is that a state actor, Becky, acting under color of law, being elected, deprived Murdaugh of a federal constitutional right because those elements are well pled. Instead, the motion attacks a single measure of compensatory damages and asserts a trio of immunities. These arguments fail for 3 reasons. Oh, do tell me. First, a dispute over one item of damages is no basis to dismiss a well-pled constitutional claim. However, if relief cannot be granted, then can yeet. They say that nominal damages independently sustain this action regardless of the proper measure of actual damages. So their argument is that other damages the court deems necessary and other damages suffered are going to carry the day. Second, the constitutional violation was decided by the South Carolina Supreme Court, but damages wasn't an element that the South Carolina Supreme Court had to decide. Under 12b-6, the second part of 12b-6 is that relief can be granted. If there's no relief here, then there's no cause of action. In the South Carolina Supreme Court, the relief was the new trial. They then say, therefore, in the absence of any further development of the record, the court should abstain from entertaining Ms. Hill's harmless error arguments. They say that the arguments are too fact-bound to consider in a motion to dismiss. Hey, Your Honor, just slow your roll, please. Third, at this stage, the court must accept the complaint's factual allegations as true, and these allegations plainly establish Mr. Murdaugh's standing to bring a claim against Ms. Hill. Here's the nuance of that. The court has to accept the assertion that the $600,000 in legal fees is what was spent. But the court may make a factual finding that even if that's true, the $600,000 in legal fee that was spent was not spent because of Becky Hill and was not caused by Becky Hill. That's not a factual determination, that's a legal determination. And the courts are allowed to make legal determinations at the motion to dismiss stage. We've seen it a couple of times. They are asking the court, hey, this factual allegation should carry the day. Becky Hill is arguing, right, but the law does not connect the two. Even if the $600K is true, the law doesn't connect that to what Becky did. They say that Ms. Hill's asserted immunity defenses fare no better. The 11th Amendment does not bar damages claims against Ms. Hill in her individual capacity. Quasi-judicial immunity does not shield a clerk's own unauthorized criminal jury tampering, conduct the trial judge would have forbidden had he known it. I don't disagree with that. And qualified immunity is unavailable because the illegality of a court officer deliberately tampering with a jury in a criminal trial has been clearly established for at least 60 years. Poot's like, I was here when the law was written. And because Ms. Hill's deliberate, concealed, profit-driven misconduct is an obvious violation by any measure, the motion should therefore be denied. The complaint states a claim under 1983, regardless of the proper measure of actual damages. I think they're probably worried about this. Do you see the language they're using? They're trying to kind of minimize the arguments made by Ms. Hill. Hill's motion is built almost entirely on the premise that Mr. Murdaugh cannot recover $600,000 in criminal defense fees. Attorney's fees. Yeah, they do. But even if that were correct, they say it is not, it would not warrant a dismissal. Yeah, it would. If relief can't be granted, then you don't have a case in controversy. Then you can't have a cause of action. Then you don't have a case because you only have one cause of action. So I disagree with that premise. A motion to dismiss tests the sufficiency of a claim, not the availability of a particular remedy. If there's no remedy, if no relief can be granted, then there's no claim. And there's no case in controversy because it's civil. They go on to say that Ms. Hill attacking the measure of compensatory damages, even that they're trying to distance. They're not saying it's the relief. They're just saying it's how you measure the damages. It's being measured by attorney's fees. Attorney's fees aren't the relief being requested. No, it's just how we're measuring the amount of money. Ms. Hill's attack on the measure of compensatory damages in this case is premature and not cognizable under a Rule 12b motion because nominal damages are available under 1983 upon proof of a violation of an absolute constitutional right without any proof of compensatory damages. And what they are relying on now is that nominal damages can keep a claim alive. So they are saying there is relief that can be granted because nominal damages are allowable under a 1983 claim. I'm real interested to see what the court does with that. They've only got one quick cite here from a 1978 and then reiterated in 2021 case saying that nominal damages redress a completed constitutional violation and sustain a live claim. But it's real quick. They say Ms. Hill's own motion concedes this, quibbling only that the complaint did not expressly invoke nominal damages, even though controlling Supreme Court and Fourth Circuit authority does not require a specific prayer for nominal damages in the pleadings. And then they're going through the case law saying that, look, we can have nominal damages, which makes this different than like the food court claims, where you can't really have nominal damages that are not directly pinned to a specific thing to compensate you for an attorney's fees, a doctor's bill, a dent to your car, or whatever it is. These are damages that are allowed because a harm's been done. Obviously, there's some damage. We're allowing for some nominal damages so that this can go forward, which is an interesting quirk to this being a constitutional violation. But it might not save the day down the road. But it might. They go on to cite another case, Farrar versus Hobby, holding that a 1983 suit obligates a court to award nominal damages when a plaintiff establishes the violation of his right to procedural due process, but cannot prove actual injury. Your Honor, we don't have to prove actual injury. We have nominal damages available to us, so we don't have to prove attorney's fees as the injury. We don't have to prove compensable damages. They go on to say that punitive damages are also available in a 1983 action, even in the absence of proving compensatory damages. If that's true, that might carry the day a little bit. Murdaugh's legal fees are recoverable under 1983. I think Becky Hill has made a strong argument that they're not. They say that Hill opens her argument with a mischaracterization of the issue as being novel. Only the factual predicate for Murdaugh's claims that Ms. Hill's shocking jury interference for personal profit is novel. They say there's nothing novel about a claim for attorney's fees incurred because of a state actor's violation of defendant's civil rights. The case that they're citing from the Seventh Circuit says, quote, expenditures for legal representation during the prior criminal proceeding most assuredly constitute economic harm. The reasonable amount of these expenditures, if proved to the jury's satisfaction to be the consequence of appellant's illegal conduct. Isn't that the question? Is Murdaugh's legal fees from trial number 1 the consequence of Becky Hill's action? And I think the answer is no. And even in the case most friendly to them, from the circuit split on this, I still think their argument fails. They go on to say Murdaugh's pleaded theory of damages is loss of the value of his defense expenditure, not causing the prosecution. I mean, I'm trying, Your Honor. Ms. Hill's causation argument attacks a theory the complaint does not advance. Mr. Murdaugh does not allege that Ms. Hill caused his prosecution. The state's decision to charge and the grand jury's indictment are beside the point. For that reason, Murdaugh does not allege that Ms. Hill caused the upcoming trial of those indictments, and that is why he does not seek recovery of costs of defending the upcoming trial. His injury is the $600,000 he withdrew from his sole remaining asset to defend a constitutionally fair trial was rendered worthless because Ms. Hill corrupted the first attempt at a trial, forcing its vacatur. So they are trying to now split hairs that the value of the trial that he purchased was nullified because he has to go to trial again. So they're not asking for the costs of trial number 2. They're entitled to recover the cost for the asset that she diminished by causing the trial to be vacated. They say the but-for chain is straightforward. But for Ms. Hill's tampering, there would have been no constitutional violation, no vacatur, no forfeiture of the value of Murdaugh's defense expenditure. Mr. Murdaugh must defend a constitutionally fair trial because the state chose to indict him. Ms. Hill did not cause that. Because Ms. Hill secretly tampered with a jury in the state's first attempt to try the indictments, Mr. Murdaugh was also required to defend a trial corrupted by Ms. Hill. The state did not cause that. I don't think that that reasoning is going to fly. All right. So their conclusion is, Your Honor, please don't dismiss it. Deny the motion. Let us continue. But they do say, if the court dismisses, we request leave to amend. Please don't dismiss it with prejudice. And the only time we would see the court dismiss with prejudice is if the court finds as a matter of law, there is nothing that can be changed. The nominal damages are something that we don't see in food court, and that truly might be the thing that carries the day. The defense went a long way to try to reframe that, Your Honor, it's the first trial that's the issue, because the second trial is going to be the one without the constitutional impropriety of tampering with the jury. The first trial we paid for, and then it got erased. It just got vacated. So we paid $600,000. It was obliterated. That's the trial we deserved. That's the trial that we didn't get. That's the problem. What could be more egregious, Your Honor, than Becky Hill interfering? But also, if we can't get the attorney's fees, we can get punitive damages if there's no compensatory damages. So punitive damages keep it alive. But, Your Honor, also, we're entitled to nominal damages even if we cannot prove compensatory damages. The argument that even if we can't prove that there is compensation needed, a constitutional violation under the law allows for nominal damages, and that is the flicker of light that keeps this cause of action alive. So please don't dismiss it. Thanks, Your Honor. I'm interested to see what the reply is. And I'm really interested to see if the court asks for oral argument on this, and very interested to see where the court goes, because this is not a cut and dry, on its face argument. These are nuanced legal arguments. The defense goes a long way to try to reframe the argument, but it's really going to come down to whether or not there's relief that can be granted here, which is why the nominal damages may carry the day and keep this alive. Now, I wonder what happens as we get down the road on this. I'm curious to see. Look, Becky Hill's attorneys made some good arguments. There was a lot of pounding the table from Murdaugh's arguments because there are some good arguments by Becky Hill. But there is that glimmer of hope, because if nominal damages carry it, then period, that's it. It keeps going forward. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.